Welcome to Under the Basswood Tree with Basswood Counsel, a podcast where we bring you brief, valuable conversations and insights to help you navigate the complex world of business transactions. From cross-border deals to international tax structuring, we cover topics across all industries. Our team and colleagues will share their insights and provide practical tips on key issues for you and your business. Let's get started.
Welcome to Under the Basswood Tree podcast with Basswood Counsel. I'm Jephte Lanthia, a partner and co-founder at Basswood Counsel. My practice covers corporate securities, where I advise clients on issues and financial services regulations. From a startup raising capital for its first round to a public company accessing the capital markets. From a fund manager launching its first fund to an SEC-registered investment advisor navigating SEC compliance. And broker-dealers working through the full spectrum of starting, operating, and growing a FINRA member firm. Today, we are fortunate to have with us Erik Dolan of Key and Compliance. Erik has more than 20 years of experience in financial services, having worked for several large brokerage firms, as well as investigator for FINRA. So Erik, go ahead and tell us before you about yourself.
Thank you. Yes, Erik Dolan, Key and Compliance. And I've been working with this firm for the last several years. I had previously worked as a compliance consultant with Erik Compliance, and we were subsequently bought up by Foresight and then ACA, and worked with them for a few years before starting my own. Prior to that, I was both in-house compliance and regulatory compliance. I'd spent time with FINRA and the MSRB and the CFTC as well over the years. I've worked in both broker-dealer, institutional, retail, and registered investment advisory compliance.
Thank you, Erik. Again, it's good to have you. Before we start, I must give the regular disclaimer that nothing we say should be construed as legal advice. If you need more advice, feel free to reach out to us at Basswood or reach out to Erik. We'll provide the contact information at the end of the podcast. And speaking about, against what we spoke about earlier about investor protection and particularly, let's deal to interfacing, dealing with clients. Reg BI, marketing. Mm-hmm. So what issues do you see when it comes to broker-dealers dealing with clients, whether it's, communication, marketing, disclosure, what do you see? What do you see?
There's a few. I think where I see broker-dealers probably most commonly fall would be where firms sometimes have old WSPs, right? At first, we kind of talked about that a little bit. They have policies, but the primary person responsible is not there. Like I said, there's certain execution, evidence of supervision that's not being done. We talked about off-channel communications. Even though that has gotten better, it's still a concern. I still see, every now and again, and I hate to say it this way, but sometimes there's a more seasoned person who's been around a while and says, oh, I know what I can text the client and what I can't. And I'm just always going, just don't text them anything. Just stop, right? So you do get into that. I think, the books and records around clients, sometimes, again, they're not necessarily that they're missing, but oftentimes they're incomplete. They're disorganized. You can't find them right away. There's those types of things. So that makes it very frustrating, especially if there's an exam. More specific, you mentioned Reg BI. I think most firms have sort of formally adapted to Reg BI, and, they're properly kind of operating under that. But there are still sort of these check the box type firms, and they look at compliance as a necessary evil and supervision. We just have to do this, and they're checking the box. But by and large, I think most of the firms are doing their best to stay on board. I think I would say there's every now and again, there's this sort of looks good on paper type of program. They're not really documenting everything to show why a recommendation was made. Right. They're talking to the client, and they should be doing is really sort of documenting alternatives. They should be sort of, making sure that there's a clear link between the client's profile and the recommendation, that supervisory reviews are being done. I haven't personally seen any deficiencies cited, but I have certainly read about some. And to me, they all seem to go back to weak execution, weak documentation with regard to policies. Like I said, not that they don't necessarily exist, but that, it's really that sort of that evidentiary documentation after the things have been done. And, we did indeed talk to them about alternatives, and here are my notes. And they're just kind of keeping things clean. And that seems to be where I to see most of the problems. So they kind of went off in different directions.
You make a good point, and for our listeners and viewers, Reg BI, again, alphabets, it's BI, regulation best interest.
Yes.
So that's what, so the best interest of the client, right? And you touched on some of the four requirements. Disclosure, you have to disclose to the client, the regulation care, and, providing them with alternative. Conflict of interest, if there's a conflict of interest, you have to still the client.
Yeah.
And of course, compliance, the record, keeping record of it. So you've touched on those.
Yeah. And to your point earlier, you've mentioned it a couple of times with investor protection. And, that's FINRA and the SEC both have investor protection at the front of their mission statements, right? At its core, right? Serving clients as a broker dealer, it comes down to acting in the client's best interest, right? Making appropriate recommendations and, providing fair, clear disclosures, right? Yeah, it does come down to investor protection at the beginning and the end.
I guess we don't want to see another 1929. That's the goal, right? But I digress. But going back to client communication and marketing, how about advertising? Again, FINRA has rules, types of communications. Can you speak to that for our listeners?
Yeah, the different types of
communication. Yes.
Yeah, you do have, it's communications with the public now, right? So you have retail communications and you have institutional communications, and it really, the audience matters, right? And how you treat it's, and if you look at the rule book, there's a lot less concern around institutional communications. You have correspondence. I must forgot about correspondence, right? But the real big part of the rule is around retail communications, because it's going out to a broad number of people, and they're not all financial professionals or institutions, right? So I tend to look at everything under a retail communications, microscope first, and then I try to look at it then. I'm not going to be, I don't want to be difficult for the firm, right? So I try to be reasonable with, knowing who they're really, because some firms are institutional only. But I always say, look, we still want to make sure there's nothing misleading. We still want to make sure that, we're sort of, explaining any claims that we're making. Like I always say, if you're going to make a claim, think of according to who, right? It's not like, in real estate, they allow what they call puffery. Even though in real estate, like RIA, like registered investment advisors, are fiduciaries, like attorneys, right? They still are allowed puffery, and you can't really get away with puffery in the securities world. If you say I'm the greatest broker, the greatest financial mind, and I'm like, if it's according to your mom, that's probably not a good barometer. If it's according to the Wall Street Journal and you were ranked in the top 5 last year, yeah, you can say that. That's factual under whatever parameters they were using, but you disclose that. But I always say, sure, you're saying according to who. And if it's a legitimate source, we can work with that. But it's very difficult sometimes, because you deal, as a compliance person, you deal a lot with the marketing people. And I always say it's got to be very tough to be in marketing in this industry, because there's so much disclosure and there are a lot of limitations as compared to other industries. There's sort of this, well, obviously you're joking. Like you can't really use that in the securities industry. So it's, got to be a little bit more careful. But you still do see violations, of course, and missteps. Hopefully you catch them up front before it's out to the public.
You're exactly right. I've seen it with clients, investment advisors or someone just, asking us to draft a PPM, right?
Mm-hmm.
You're making certain disclosures, certain, claims, where I will tell what this claim is, can you back it? Is it, to your point, according to whom, again, that's another topic, but again, we see it with AI washing, right? We've seen investment advisors claim to use AI or companies claim to use AI. Again, so this puffery is a step too far.
Right.
And we see a lot. So I would say clients, well, you cannot really say it unless you can back it up.
I tell everybody, treat the communication like it's going to be reviewed by a regulator. Right. And because, there's a chance it very well eventually will be. So, just treat the communication like the regulator is going to see it tomorrow.
Definitely. I'll make the point to not only the communication and the number of persons to whom the communication is going to matters, right? If it's under 25, so again, clients always know those, those rules. So that's why you check with legal compliance. Is the intended person in the number 25 or less? Or to your earlier point, is it retail? Is it someone who's institutional? So those issues, broker dealers, compliance personnel, should be aware of. And again, when in doubt, check with compliance, check with legal.
Absolutely.
Switching gears, we mentioned technology a few times. Think about, popular, right? We've gone a long way since the Buttonwood Agreement. I'm taking you back, right? Since 1792, the Buttonwood Agreement, which gave rise to, to the New York Stock Exchange, right? So now we've gone far to using technology, AI. So what are you seeing, and what are you've touched on them a few times, what are the bits? Because I know FEMA had a survey a few years ago asking firms that are using AI, how do they use it? What are they using for? So can you speak that? What you're saying? What are the basics? Again, social media, AI, etc.
Yeah. In fact, they do still ask. They send out the technology vendor questionnaire every year, and they did add, "Are you using AI for supervision or compliance?" Something to that effect. But they do ask about AI now, and it's funny because I never, up until this year, honestly, I'm not opposed to AI. I get it. It's very good for surveys. I never had to use it from a compliance standpoint. But now some of the email review, some of the retention companies will offer a service where they'll review for keywords. The AI will do the review for keywords. Now, I'm still reluctant at times, so I'll let it kind of pull the keywords, and then I still want to see it. And whatever, because it is smart enough to read the rest of the sentence and say, "Oh, that's not a problem. That is a problem." So I still kind of go back in and look at it again, because I get nervous. So that's for me, even that's brand new, right? So, but broker dealers, especially your small, mid-size, right? They're increasingly using technology of all sorts, including AI, right? But mostly it's still sort of in this modular kind of, right? Email review, communications archiving, trade surveillance. You're now using it you're sending out which I welcome, for your outside business activities, political contributions. It's a lot easier than fillable PDFs back and forth. It's, now it comes back and forth through the system. I think the, smaller firms, right, it really helps kind of create sort of a faster, more flexible, more nimble way to approach supervision and compliance, and that you can audit it. It's timestamped, when you looked at it, right? So you can really get quite a bit out of it. Like I said, from what I'm seeing with AI it is working so far, so good, right? Firms do use it to varying degrees, of course. But like I said, communications and surveillance, there's been what I've seen the biggest use, because it flags quickly, and it really does. Emails, chats. I think that really is valuable to supervisors and compliance officers. What you don't want to get into is, and people, you've seen this you've seen this with law firm, with attorneys, you've seen this with compliance professionals, right? That there's an over-reliance sometimes, and you're not making sure. You still have to ensure that the output is accurate, right? So you still have to verify the information, right? There are people who just put it in the chat GPT. I hear people say that pretty frequently. I say, well, if you do that, you still have to go back and make sure. And I have no problem with doing that. Sometimes I use it to sort of get me on track. If it's something comes up and it's a rule that I haven't dealt with, or it's a rule that I haven't seen in a long time, and I'll say, what is the rule on this? And it'll say, oh, it's this rule. And now I can find whatever other rules there are and whatever interpretations. You can use it as sort of a starting point, right? A starting block. But yeah, I think, the reps, the supervisors, they all still have to understand that they are still, regardless of what AI said, they're still responsible, that this is going out under their name and this is being approved under their name. And, you're still on the hook, right? It doesn't matter if the technology was wrong. So you still have to make sure you're, like I said, you can use it wisely, and it can still make you a lot faster and more efficient. you still have an obligation.
I agree. I agree. Just think using AI is, well, it'll be around. It makes things efficient. Onboarding, communicating,
Absolutely.
archiving, compliance. It makes sense efficient. And to your point, you still, you still have to go back to the human eye checking it. And to your point that, you still have on the hook for it. Sidebar to your point, but lawyers using AI. I've used it, right? And I'll get a response where the response looks fishy. Again,
Yeah.
go back to experience, right? It's like,
Yeah.
well, this is not silent. So let me double check. So again, going back to that experience, that human eye, again, that compliance aspect too. If we use it, speaking of the firms, if we use it, how do we use it? What is, the process for double checking? So again, so firms that are using those technologies should consider how they're using it and how they are telling their clients. And you mentioned that in passing earlier, we'll go back to vendors. That what are some of the vendors that broker dealers use? If I'm starting my firm beside the compliance person, so what are some of the vendors that I should consider, and what are the risks, and what should I require of them?
Are you
Question.
asking specifically for the vendors?
Types of vendors, and
all right. Like I said, there are vendors that do electronic communications. Right. There's that will do your outside brokerage activity, right? Surveillance. There are vendors that will establish your general, in the RIA world, they call it the code of ethics, right? But the broker, it's your annual requirements of, disclosing your outside business activities, political contributions, private securities transactions, things like that. Right. And then you also have your sort of typical document management systems, right? I would say those are the big kind of 4 types. Yeah, those are probably the big 4, right? And then you can use them for anything else. But I think that's the biggest 4 that you're going to see.
Yeah.
With anything, and we mentioned 17A4, right? You have to get an undertaking letter from them, which is basically a letter from the vendor that says, yes, we keep and we retain everything in compliance with SEC Rule 17A4. So you have to have that assurance from them that they're doing that.
I'm glad you mentioned that on the taking a letter, and a lot of times that's what we always tell clients. When you're getting vendors, whether it's the AML vendor, the cybersecurity vendors, understanding again their system, and understanding whether there's a fourth-party vendor, and how are they complying with securities laws. So again, if there's a breach, particularly if it's somebody, ST, privacy issues, how are the vendors addressing it, and are they notifying you in time for you to notify your clients, in legal and compliance to comply with the rules under
Yeah. Well, that's scary because we're hoping right now that the vendors, there's regulatory requirements, right? And oversight, and, you hope that the vendor, is getting back to you and it's not too late, right? Because if there is a problem, you do need to, you have to let the vendor know. Sometimes you have to let the clients know, right? And yeah, that is always a concern that kind of sits in the back of your mind. But hopefully they're letting you know.
Which also goes back to the supervision issue, right? The broker has a duty to supervise a vendor.
Yeah, yeah. That's to your point. You can't say the vendor didn't do their job. That's not an acceptable, right? It's still your failure to supervise, and then you have to deal with that in another way. So, right.
You cannot have rules without enforcement. So let's talk inspections, investigations, and exams. So can you talk to what are the types of exam, and if a client gets a letter, that they'll be examined, how should they prepare for it?
Yeah, it depends on what they're asking for, right? But I think, with anything, right, FINRA's going to start with data on their side, right? They're looking at your, any filings you've done. They're looking at your business lines, any prior exam history, right? Any activities, communications, surveillance, maybe signals that they're getting from their review. They're going to look to see if there's customer complaints or tips or disclosures or anything like that, right? So when you get a notice as a broker dealer, right, the immediate response is to make sure you have everything. Call your lawyer. Yeah, that's the first thing they do. I always get accounts on board. But you want to make sure that everything's organized and you have everything under control, like you know what's out there, right? I always say designate a point person. Usually that's the chief compliance officer or counsel. It depends on firm, but you don't want fragmented response. When I was on the regulatory side, I didn't want to get emails from, responses from a bunch of different people because it just felt like it wasn't, and I think it makes you look bad. I think the firm just, at some point, there's going to be, something's not going to mesh. And so I always say designate a point person, right? And then with counsel, of course, you analyze your request, you map it out, see what are they asking for, who internally is going to have the answers, right? It could be the FinOp, it could be IT. Oftentimes, people automatically assume it's the CCO all the time, but sometimes they're asking for things that may not be immediately available to the compliance department. It might be something that the IT vendors were working on, and and then you want to start assembling the documents immediately, right? Not just what they're going to most likely ask for certain things anyway, but get your WSPs ready. They're going to ask for communications of some sort, typically, whether it's a time and date from this day to this day. They may just ask for everything from this day to this day. They may have keywords. They may ask for trade records, outside business activities and approvals, reviews. And you want to make sure that everything, I mentioned earlier, you find these documents where the principal never signed it. Well, sign it, time to sign it, right? You can't backdate it, but sign it. At least you can explain that, I talked to them and we spoke and I reviewed it ages ago, but I forgot to sign it, so I signed it now, right? But just make sure, because it's better to have it late than not done. And then, you want to make sure that everything is matching what they're asking. You're going to have to do a gap check of some sort, right? Typically, make sure that nothing's missing or nothing's weak. If it is, you want to catch it early. So I say, do it right away. Talk with counsel about it. Make sure everybody's on the same page. I hate to say it like this, but aligning your story. I don't mean to make sure we have our story straight. I don't mean it like that, but you're telling the truth. I want, everybody's, but just make sure nobody's forgetting something or has something wrong, a fact wrong, and there's something, right? Make sure everybody has an exact understanding of how do we describe what the firm does? How is supervision done? How are the risks controlled? Because not everybody may know what somebody 2 levels above them does. So they could say, well, I don't really deal with them, but here's my understanding. And you can explain it. So then your story is concise and everybody's aligned. And it's not that you're misleading, but you just want to make sure that everybody has the right understanding and accurate understanding.
And to the point that you made earlier about training, that goes back to training, right? You don't train for the exam, you train regularly.
Right.
And so when the exam or inspection comes, everyone knows what the firm does, who does what. So again, that goes to, having procedures in place where you train regularly.
Right.
And to piggyback to an earlier point about exam, but again, it depends on the exam is asking and what type of exam. If it's a sweep exam or if it's a cause, there's something specific that the SEC or FINRA is looking for. And I'll tell a client, the most specific, like if they're asking about specific transactions, specific clients, you really need to call it, because at that point, there'll be something that
there's a red flag. Yeah.
And we would article a few weeks ago, but the SEC was noticed. I would article about that. And so our listeners can go on our website article on SEC enforcement and the was noticed. I mention it because, to your point, when there's an exam, the investigator is communicating with you about an opportunity to respect. Because at that point, you have not crossed to enforcement, right? It's like, an inquiry between trying to see what's going on here.
Yeah.
But to the extent that, again, there are delays and there are significant red flags, that's when you start getting in the was notice will refer to enforcement.
And when something goes to enforcement, it doesn't always mean that something's definitely wrong, but it does mean that they suspect something may definitely be wrong. And sometimes, it depends on how reasonable the examiner is, quite frankly. When I was in enforcement, it's not that the examiners were doing a bad job, but if you get somebody who's relatively new, they may not quite, and they may send an action to enforcement that maybe doesn't need to be in enforcement, right? There was cold calling violations in a branch or something. But the problem is once it gets to enforcement, they have to act on it. Enforcement can't review it and say, no, I'm not, like, this isn't really worth pursuing. They have to do something. So they have to send a letter, right? You send a letter and you ask for things, you ask questions about, like I said, there was the one that I ever had that was actually not enforcement worthy was a cold calling. The branch they were cold calling all these people and after 9. And so we talked to the firm and they said, no, we caught them. We caught it. When everybody had to go through training. So that was the end of it. I didn't even take testimony. It was one of those deals where they caught it, they addressed it, they took care of it. Everybody got, extra training. It was mandatory. The firm sent proof of that, the sign-in sheets and all that. And we were fine with it. So we closed it. But you still have to go in that. You have to take action. So that was an interesting one. And there are other times when something comes to enforcement and you realize, okay, what they were doing actually was okay. You could see why it looked like it wasn't. But as you start digging in more and taking more people, doing more interviews, conducting more interviews, you start realizing, oh, that's okay. That wasn't actually a problem. So you can back off of it a little bit. But then there are other times where you dig in and you find more and more and more. You're going, oh my God.
And to your point, just enforcement or even recognition for enforcement, or even if a civil charge is filed, there's always the presumption of innocence. So it hasn't been determined that something is wrong. It's just saying that, okay, well, there's something could be there. The firm is presumed to be innocent, but again, you just have to look deeper to make it. And something else that you mentioned as far as cooperating with regulators. I believe there was also part of the old SEC enforcement manual. I believe the new SEC enforcement manual gives credit for not only cooperating, but for taking remedial steps to remediate a problem before the SEC or framework gets involved. Yeah. So that gives firms incentive to take care of it before it gets out of hand. And of course, document having taken care of it.
Right. No, that's exactly right. And it's cooperating all along, I think, too. Sometimes some people just have a natural tendency, especially if they don't feel they did something wrong, get defensive, right? And I tell people, don't get defensive. Just answer the questions, send them what they're asking for, ask them if they need anything else, say thank you, right? It's not all that different from, if you roll the stop sign, right? Roll your window down, put your hands on the wheel, keep everything, hey, you got caught, it happens.
Stick to have your lawyers involved soon as that.
Yeah.
Waive any privileges or anything that you should,
You just don't want to give them reason to have their guard up. Their radar goes up all of a sudden and you're going, like, why are they? Because you were sort of getting frustrated with them right away. I try to tell people, remember, they're doing their job. Right? They don't want you out of business. They don't want to have you have something wrong, right? You said it's a member organization, right? Paid, right? There are fees. They don't want people out of the industry if they don't have to be, right? If they're good people and your mistakes happen, they're just doing their job. And I think people have to remember that. And don't get defensive, like you said, and cooperate. Let your lawyer do that.
Going back to something we said earlier, it's still a human business, right? It's still that, the regulators on a machine, right? We all use technology, but it is a human interaction. It's a human business. So, when you're communicating with your examiner or the regulators, for the most part, the point, they want you to succeed. They're not coming after you. Right. So it's human interaction.
Absolutely. Yeah. And I always make it a point, because every firm has a designated, right, analyst, and I reach out to them and I let them know what we're doing, right? This firm is going to be filing a CMA. We talked about they're going to be expanding their business. I call that person ahead of time and I say, hey, just heads up, they're thinking about filing a CMA. They may get into this type of business. Let me know if you have any questions before we file. And that goes a long way because sometimes they'll ask questions that, I hadn't thought of too, right? It's, that's a good point. Let me make sure that the firm understands this and, that. So it's a people business, right? No matter, you're not on opposite sides.
Our listeners and viewers. Okay, right. So what you say, every FINRA firm has a designated analyst and FINRA, right?
Within FINRA. Yes. Yeah.
So
yeah, I don't remember the title now, but yeah, you do. Every firm there's a group within FINRA that their job is to actually be a contact for the broker dealers to go to with questions, with concerns, just to be there, to be the person to, like I said, notify them if you're going to, if you're looking to get into a different type of business. And I've gone to them with questions, just to kind of ask what they've seen in the past from other firms. I've been just about expense sharing agreements, about listen, hey, what have you seen included? I want to make sure I'm not missing something. I've done my research. Here's what I've come up with. And they'll say, well, with other firms like yours, here's kind of what they have. And you're very helpful. They're really there to, to be an ally on some level. But again, they're doing their job. If they find out that you're doing something wrong, they have an obligation to refer you. But overall, it's been a very good experience from what I've seen.
I know we are running out of time, so let's get to our last topic, which issue, which you've referenced, the CMA process. So now I've been running my firm, and business is going well. I'm thinking about expanding or closing shop.
Yeah.
Or selling. So what is the CMA process, and how should firms approach it? And when is it triggered?
Yeah. So the key question, so CMA, right, continuing membership application, right? It's similar to, we talked about the NMA earlier. And
Remember,
it's a similar process, right? But the key sort of question with a CMA is this change, whatever the change is it material to the business and the risk profile really of the broker dealer? So if you're making a material change, right, in business operations, for example, you're adding a new line of business, a new product type, right? Or new customer base. Maybe you're institutional only. You're going to start working with retail. Then you may have to file a CMA, right? That would be basically getting approved by FINRA for the next line of business, because sometimes people forget that they were only approved for one line of business. So you have to remind the firm, hey, you're approved to do institutional only, but private placements, mutual fund sales, whatever it might be. And now you have an opportunity to get into another type of business. Some opportunities come up. So, look, that's a change in business. That's relevant. That's material. So let's file a CMA, right? And that's, I think that's really the sort of the rule of thumb, right? Now, you mentioned if it's, well, you didn't mention that, but if it's not material, then you can make an administrative, non-material change just on your Form BD, right? Just an update.
The amendment.
Right. So it's, an address change. Maybe there's change in the control persons that are, don't actually own a stake in the company. You can, you can make minimal, not non-material administrative changes on Form BD. You don't have to file a CMA for that, but it's the really the materiality that triggers the CMA.
And not to class to your point, again, material, again, that's I guess a legal term, for the most part, change of business, line of business, so clients should definitely speak to a compliance lawyer, whether they need a Form BD amendment or an actual CMA process, and if they are having a partners where there's control of ownership, I think 25%. So if there's a control of ownership, that's a material.
Yes.
So again, triggered. So they should consider, again, is this a BD or CMA process?
Right.
I know we did not get a chance to talk about audits, end of the year audits, and cryptocurrency. So this is a topic for a whole another podcast. But what else would you want to tell our listeners, about, again, compliance from beginning to end? I mean,
It's a loaded question. To be aware of the one thing that most, I would say, broker-dealer principals sort of underestimate, right, is the ongoing operational kind of burden of compliance in some ways. Not a burden to me, but a burden to people trying to do other things, right? There's always the plan when you're starting a broker-dealer. And I think this is really what I want to let people know, that you always know that you're going to have people that need to be licensed and you're going to have this initial launch plan. There is a reality that every day is really a supervised environment, right? And you're not just talking about the big item. We talked about exams. We talked about different filings, but there is constant documentation. There's constant continuous supervision. There's vendor oversight. Being able to prove that you're doing what you say you're doing, right? And I think what surprises a lot of people is they start to realize, like I said, they initially kind of look at compliance as a necessary evil. Like you said, it's not a cost center. It's not a revenue generating area. And it's very difficult to quantify fines avoided, right? So the things that didn't happen, it really is. But I think the good firms, and you really do see this, compliance is the infrastructure of the business. It's not just doing the deals. It's not just making sales, right? It's maintaining the system that can withstand scrutiny. So you can go ahead and do business and make sales, right? So I think that to me is, the biggest takeaway. People need to really understand that. Build the framework first. Don't try to sort of reverse engineer compliance into your business. Build a framework, have it there.
I mean, you mentioned that before, that even selling money has a net capital, right? If under the requirement, you have to stop operations and notify frameworks. And so something as simple as that, you have to have the compliance. And I always tell clients, it's easier, I think it's easier to engage compliance, engage security lawyers in the front end than having to pay a defense lawyer, right? You cannot quantify how much you save. From your experience, from my experience, it's more expensive having to fix it on the back end.
Yeah, absolutely.
So how can our listeners reach you if they have questions, if they have follow-ups? How can they reach you?
Yeah, they can reach out to me on LinkedIn. It's Erik Dolan, Erik Dolan. My website is Kyan Compliance, KYAN compliance.com.
And of course, you can reach out to us at Basswood Counsel. If you need to reach out to me, you can find me on LinkedIn, Jephte Lanthia. So Erik, thanks for your time. It's been fun. We can do it all day. And thank you to our listeners and viewers for tuning in. We hope you enjoyed this episode, and we invite you to sign up for the event Insight. Again, thanks for your time. Thank you.
Thank you.
We hope you enjoyed this episode. To stay up to date with the latest legal insights and Basswood events, please follow us on our Basswood Counsel LinkedIn page and visit our website at www.basswoodcounsel.com. Thanks for tuning in, and we'll speak to you next time.